I will actually step back a little bit and will not be as practical probably as my first speaker, and will still go back to really international legal framework, international human rights standards that kind of underpin this field of work. And in the same time, I will not be looking so much at victims, but rather on the other side, so to say, on children in conflict with the law, and especially on the individual assessment and the requirement for the individual assessment in the child justice process. I will be looking also at the challenges that we have so far identified with this process, and I'll be basing myself a lot on the preliminary results we have so far from the practice project that is currently being implemented in the Czech Republic and Slovakia. So maybe just to say very briefly something about the International Commission of Jurists. We're a global human rights organization with quite some history, founded already in the 1950s of the 20th century. And the ICJ is really looking for contributing to the interpretation and implementation of the human rights standards to be more progressive. And so we're really looking at a range of human rights issues across the world and across the regions. We have a number of regional programs. And I'm based in the Europe program of the ICJ. So it's interesting, especially for me, this project, because we've been working a lot also on migration, on the rights of migrants and refugees as one stream of work, but we're also looking at the rights of children, and especially children in child justice system and children in conflict with the law. And so this project somehow also merges these two areas, which is really interesting. So just to give you a bit of a background of what we're currently implementing by the Europe program in the EU. We're about to finalize this project called Practice, which is really looking at the individual assessment of children in conflict with the law, which is based in the Article 7 of the Directive 2016/800. And within this project for the last 2 years, we've done a baseline study. We did research in a couple of countries, in Belgium, in the Netherlands, in Finland, and in England and Wales, as well as in the Czech Republic and Slovakia. That's the kind of two main focus countries of this pilot project, where we then also did some national trainings for the practitioners that are involved with the individual assessment. These were mainly judges, lawyers, and social workers. And we're currently drafting recommendations on the main principles governing the individual assessment of children in conflict with the law. Just to also complement this perspective that we're having, especially in this region, we also have just recently received a decision in the collective complaint that we lodged ICJ with the support of Forum for Human Rights, our Czech and Slovak partner, and it was a collective complaint that concerned children in conflict with the law below the age of criminal responsibility. And I'll speak about this specific group in a bit later, but it was a very important decision by the European Committee on Social Rights. And the committee found a violation of Article 17 of the European Social Charter for lack of access to legal assistance and lack of access to diversions. So this is some kind of our background, but now really to move on to what is individual assessment. And as I said, we're basing ourselves on the most recent EU legislation on this, although this institute in itself is not entirely new. But so it is based in the Article 7 of the Directive on procedural safeguards for children who are suspects or accused in criminal proceedings. So what it is by the directive, it says that member states should ensure that the specific needs of children concerning protection or education or integration are taken into account So usually, really practically speaking, the individual assessment would be in most countries a report by a social worker or by a specific body, where usually there's a contribution by a number of actors, and that's also this multidisciplinary element of the individual assessment. So it's not entirely set what exactly needs to be in the individual assessment. That always would depend on the circumstances of the case and of the child. But I think what's really important is the purpose, is what is actually the goal of the individual assessment, what it should actually serve for. And so when we look at Article 7.4 of the directive, it has really three main aspects, saying that the purpose is determining whether any specific measures to the benefit of the child are to be taken, assessing the appropriateness and effectiveness of any preliminary measures, and assisting in taking any decisions in criminal proceedings, including sentencing. So you can see here that actually most of the purpose is really linked to the proceedings themselves, that the individual assessment should really help the child in the proceedings, so that the process is somehow reflecting the specific circumstances, the needs of the child, the specific vulnerabilities of the child. And sentencing is just one very last part of the purpose. But this was very interesting for us to see also in the research we did in Belgium, the Netherlands, or Finland. Basically, in most countries, the individual assessment is done, but mainly is being then taken into account for the sentencing. So it's not really there in practice to influence the proceedings, so to enable the child actually to have their right to be heard, really effectively participate, to have their best interests really taken into account. Usually it's only used for to inform the sentencing. That's usually the moment where it's really looked at. So that, I think, is already one kind of critical remark we would have on the practice, and there's a number of other challenges. So as I just mentioned as well, it's not an entirely new concept. Actually, already more than 100 years ago, when the child justice systems were coming into life, the aim was, it was already there. It was put into the legal framework. And the aim, at least in the Czech and Slovak context, but in many other countries as well, was to find the most suitable measure for the child and to contribute to the re-education of the child. So again, it was really looking at the impact on the sentencing, and it was not at all kind of grounded in this rights-based approach. So I think that's also something, and that's why we also put so much emphasis on the international legal framework, because that's really shifted during the last century, and especially with the UN Convention on the Rights of the Child and other standards that really have shifted now to child protection, away from child protection approaches, really that were more like patronizing, just doing things for the child from the adult's perspective, that we know what's good for the child, and the child would really be treated as an object in this protection approach, and moving towards like a rights-based approach, where the children are seen as rights holders, and they are really those that can also make decisions about their lives, given their level of maturity and access to information, and so on and so on. So that's, I think, the biggest shift we also want to show, because to some extent also the text of the directive, to some part, may be still also reflecting the old system, but as it has to be read also within the current international human rights framework, it's very clear that the shift has been made. So yeah, as I said, so the individual assessment for children is important because they're in a situation of vulnerability. They're entitled to procedural rights and safeguards, and especially because the judicial proceedings will have such a high impact on their life, it's really important to make sure it's being used. And if it's used well, then it can definitely increase the effective participation of the child. It can determine their best interests. That can actually also help to prevent discrimination and further improve access also to the procedural rights of the children, especially when they have special needs or special vulnerabilities and so on. So moving on to the international legal framework, I mean, basically we have a list of international human rights standards that are all applicable to children, suspect or accused. And so based on that, you know, every child is entitled to a set of rights. So I think this is really the starting point that we need to take. Especially with procedural rights, I think it's really important, and that's why I will also speak a little bit more about the judgments, because traditionally adults would have access to procedural rights, access to their lawyer or access to information, and children were not having such set of rights because they were really still in this protection approach, so they wouldn't really be given access to the rights as rights holders. So definitely we need to look at the UN Convention on the Rights of the Child. I just really briefly mentioned, because I think, you know, most people in this conference are very familiar with this, but just not to omit anything important. We have very important guiding principles set out in the UN Convention on the Rights of the Child: the best interests of the child principle, right to participate and right to be heard, non-discrimination, and right to life, survival, and development. And so also in our work and in the recommendations for drafting now, we really try to use these and really apply them on when the individual assessment is practically being done. And then, in Article 40, we find more information on children in conflict with the law, while what I think is important to stress that really children should be treated in a manner consistent with the promotion of sense of dignity and worth. So let me just mention a bit more about children below the age of criminal responsibility, as that may be sometimes quite a difficult situation. These children may be forgotten a little bit. I can give an example in the Czech Republic, where children aged 15 to 18 take part in the juvenile justice process. They can be criminally liable. So there is a Juvenile Justice Act that applies to them and grants them a good level of procedural rights. But children below the age of 15 do actually not have any access to such procedural rights, while in the same time they still can be actually subjected to very formal proceedings. They can be interrogated for hours sometimes without access to a break, access to a parent, access to a lawyer or anyone else to support them. And in the same time, the measures imposed on these children, even they're not criminally liable, can still be quite harsh. And it can amount to deprivation of liberty as well in maybe a psychiatric institution or educational institution. So I just want to mention here two recent cases. One is Blokin versus Russia in front of the European Court for Human Rights. And one is the collective complaint I mentioned earlier, ICJ versus the Czech Republic, where in both cases this looked at children formally below the age of criminal responsibility, but both the committee and the court have really looked at the practical way of the proceedings, how they're ongoing, and what is the result, saying that the fact that these proceedings are classified as civil that is not decisive. It does not mean that these are not actually these are not similar to criminal proceedings. And so that's why also children that are below the age of criminal responsibility should even less so have weaker legal procedural protection than adults. So in both cases, it's an interesting ruling which really gives like power to access to procedural rights for these children. So there's a number of international instruments that speak about, especially about access to justice and access to procedural rights, especially child-friendly justice. Principles are all very much relevant here, especially for the individual assessment. There's also a special requirement for the proceedings to be conducted in a language that the child fully understands. So just to flag that, because that may sometimes even not be in line with EU law, which may sometimes in certain situations say it's a language which the child is reasonably suspected to understand, while international human rights standards are very clear on that it really has to be a language that the child fully understands. And that I think is quite relevant also to the topic of the conference. Then obviously we have a set of procedural rights and guarantees. The children have to have access to legal assistance and to legal aid as well, from ideally the earliest contacts with the justice system. They should have access to information, and that's quite important, because they also need to have really access on what is gathered on them throughout the individual assessment for the report. I mean, the individual assessment report is there to help the child, but it might not always be helping them in practice. And that's also why we're actually doing this project, and why we're drafting these recommendations. So this would be one very important safeguard, that the child has access to what is being written about them in the report and be able to comment on it, which also would be stemming from international human rights law. But unfortunately, it's not always the case, and the child does not always know what is being said about them, or cannot express any comments on it. And then the right to interpretation, just to stress as well that it should not be only for their contacts with the justice system, but also to be able to communicate with the lawyer or with the guardian. So individual assessment does not appear to a large extent in international human rights standards, but we still have a couple of mentions, such as in the Beijing rules, that say that the background and circumstances of the child, especially in which the child is living, must be considered. And like in this case, in this connection, I just need to also highlight that a lot of times there's a lot of problems already stemming from systemic discrimination and basically the environment in which the child finds themselves, the environment in which they're growing up, which can have sometimes negative impact on their lives. And the fact that this is considered in the individual assessment, it's important, but it also has to be used in a correct way, and not to the detriment of the child, which again, sometimes unfortunately is the case. The Havana rules say that the child needs to be interviewed as soon as possible when they're detained, and they must be, a report must be prepared identifying any factors, looking at specific type and level of care and programs that are required. And the UN Committee on the Rights of the Child also encouraged the individual assessments of children in its General Comment number 24. Here, just to mention, obviously, a very important decision, DNV versus the UK in front of the European Court for Human Rights, which really spoke about the effective participation of children in the criminal trial and the need for developing some procedures of the individual assessment. So that also the court very much acknowledged the need for that, as well as in Blokhin versus Russia. Under EU law, I've mentioned already the Directive 2016/800, which is kind of the crucial one and where the individual assessment is rooted. But it's also important to look at the EU Directive 2016/680, which kind of came together with this other directive as a package of procedural directives. and it's looking at processing of personal data within the criminal justice system. It's not only focused on children, but it's a very clear and very specific directive, and very clearly states for which reasons and purposes can still personal data be collected, and how they need to be processed, and how they can also be shared between subjects. And as well, it mentions the right to access to the data, unless there's very specific limitations that would apply. So that, I think, is again quite a basis for to challenge basically a lot of times the practice that I mentioned before, that data is not shared, the information is not shared with the children. And even more so, the data is also very often in practice shared without any boundaries. So it's really, there's this holistic approach or multidisciplinary approach that's always being highlighted by the institutions, but it also needs to be really done in a way respecting all these standards, because if that's not the case, it really violates a lot of these standards. So in practice, there may be a social worker just receiving an information and sharing it very openly with all the other actors that are involved in the individual assessment process, while they're not actually supposed to. They might not need to share every single information with all the other actors. What is a very problematic practice as well is the lack of citation, lack of including specific sources for an information. So there's often one information that may come from the school, from one person in the school, which then the social worker would just put into their report without any citation of a source. So this information will appear already in the report from the school and then in the report from the social worker, as if these were two independently coming in information, but it's actually just a duplication of one information that may or may not be correct. And sometimes this information really can get multiplied. And so I think we also realized that a lot of times in the Czech Republic and Slovakia, there is a very high level of institutional trust, which may be sometimes higher than trust to the person themselves, trust in the child and what they're saying. But if there's something that comes from the school, the psychologist, the social worker, even if the source is actually not being verified, it will take precedence, it will take over, and may actually distort the reality. So, I mean, I mentioned already a couple of the challenges throughout. So just to kind of sum it up, I mean, what we have at least been able to observe in the Czech Republic and in Slovakia, but I think to some extent, a lot of these elements appear also in a lot of other countries. So that's definitely the lack of participation of the child. So the child still is being objectified. The individual assessment is still being approached in this very old-fashioned manner, in this protective welfare approach towards the child. So even though the social worker may talk with the child, that doesn't mean that the child really participates. They use them as a source of information. They ask them a couple of questions, but that might not mean that they actually are really involved, that they can actually participate in the individual assessment, that they can actually raise their opinions, and especially that they can comment on the report. So as I mentioned already, there's really this uncritical institutional trust, and sometimes holistic approach might mean a lot of professionals speaking with each other, but not with the child. Then we wouldn't think that's really the good practice. As I mentioned as well, the rules of exchange of information among professionals seem to be very unclear, and sources are not adequately cited. So that really leads to a multiplication of information, and child is not given access to the report. So that really is a problem. And I think probably the biggest issue we have seen is really stereotypization, or some kind of discrimination based on the background of the child. So there's structural deficiencies that usually these children will be facing, such as social exclusion, poverty, or just inadequate access to resources, basically, which can then, you know, in the report with already some kind of a prior bias be used rather not in favor of the child, not as a right of the child and to help them in the proceedings, but rather to their detriment. So it may be kind of putting the child in a very stereotypical view. I mean, Roma is the biggest minority in the Czech Republic and Slovakia. So usually, you know, this label of Roma from a family, parents don't work, child skipping school, or parents alcoholic, all these little points will be actually used just to kind of picture the child as someone who's problematic or who should be put in a educational center with deprivation of liberty and so on. So that's actually really worrying, that rather than, you know, using the child justice system as an opportunity for the child to really also be able to share their aspirations and their kind of ideas of what they want to do in life, and that kind of being taken into account in the process, and perhaps even helping the child to get on a right track, so to say, it sometimes only adds to their already situation of discrimination in the country. So that's all from me. I just include some final questions as well. It's more also things that we're kind of thinking of when drafting the recommendations in this project, like how to actually make sure that the individual assessment will be carried out in a non-biased manner. Because, for instance, we had discussions about the lack of concrete methodology, but then we're also quite worried about, you know, just solutions that are like tick box methodology. If you don't actually change the overall approach, it may not be really a solution. Then another question, obviously, how to make sure there is a participation of the child in the individual assessment, and how to make sure that really it has impact on the proceedings, and that these are adapted following the individual assessment. So thanks so much.